I'm Patrick Cawley. This is Dementia Empowered, a podcast helping family caregivers navigate dementia care, overcome legal and financial challenges, and settle into a peaceful routine of confident caregiving. Keep listening, and you will hear why having a parent with dementia pay family members or friends for the caregiving may be a very good idea worth considering, why having that payment arrangement in writing is essential, and finally, what should be in the written caregiver agreement. Let's start with the obvious. You're working really hard as a family caregiver for someone with dementia. You are the outsourced healthy brain of that person. You are doing the rational thinking that they are not really able to do anymore and really won't be able to do in the future. You are managing their moods and their emotional needs. You are managing their physical needs. You're managing their money. You're putting in a lot of effort, and you probably don't want to go it alone, but you're putting in a lot of energy and time and money by yourself. And so this all adds up over time. It becomes a bit of an emotional strain. And it's one that we family caregivers do because we love the person in our life who is living with the brain change of dementia. But over time, there is emotional strain, especially with the irrational thinking and all the questions and the things that you have to keep up with while managing your own life. There is physical strain, especially if you are sleep deprived, or if there's also physical mobility limitations and you're having to do some lifting. The physical strain also adds to the emotional strain. And eventually there's financial strain. If you're picking up things at the grocery store, or the pharmacy, if you're chipping in for this or that, if you can't work, that's a big one. There's financial strain. Think about that. How much does caregiving, if you are still working, affect your ability to earn an income? How much does caregiving, all of this work you're doing for your loved one with dementia, affect your time with your spouse or your children or your friends? When's the last time you went out to lunch or grabbed a drink with friends like you used to? When's the last time you went to that book club or just out to a movie or whatever you do with your friends? Inevitably, caregiving takes you away from some of that. There are sacrifices that you are making. And so all of this adds up to cause people eventually to feel like maybe all of this strain and effort is not being recognized. Being paid as a caregiver, even if it's a very modest amount, is an acknowledgement of what you are doing. It's an acknowledgement of the value you are providing. Studies have been done on this. You can Google this. There's an AARP article on this. There's some other places it will show up. But caregivers, friends, family, not professionals, but family caregivers who are paid report greater sense of well-being than the family caregivers who are not paid. And I think that's just a psychological byproduct of being recognized for what you're doing. You are putting in a lot of work and making sacrifices. So even a modest amount of money is a recognition that provides a psychological benefit for you. A more technical point, but a benefit of being paid as a caregiver also comes into play when Medicaid is at work. When Medicaid is the social safety net that pays for long-term care, they have some very picky rules. And especially if your loved one with dementia does not have a living spouse, elder law attorneys work very hard to get your loved one eligible for Medicaid, which means having really no money to their name at the time Medicaid starts paying thousands and thousands of dollars every month for care, but working in the way that the law allows to keep money in the family. But inevitably, especially with no living spouse of the person needing the long-term care and Medicaid to pay for it, money will be lost. So getting paid for care now keeps more money in the family. Even if it's a modest amount of payment, every little bit helps. It adds up over time. So whether it is a psychological benefit, being recognized for all of your hard work, or whether it's a more technical benefit where you're going to lose money to long-term care as dementia progresses and needs escalate and facility-based care might come into play. That's extremely expensive. The Medicaid rules may not allow all of the money, the lifetime of savings of your loved one to be preserved. But if in the meantime, there's payment for care, you're doing more to keep that hard-earned savings in the family, which in my experience is exactly what your loved one has always wanted. So let's talk about if you have a payment arrangement, you're getting paid for caregiving, why having it in writing is essential. First and foremost, it formalizes the caregiving arrangement. So who is doing what and when? And who's really committed to providing consistent care for your loved one? Having people locked in and committed is so important because if you haven't seen it already, you start to talk to people about all that you're doing for your loved one with dementia, and maybe family members or your loved one's friends say, "Oh, well, just give me a call. I'm happy to help out however you need me." But are they? How committed are they? When someone puts their name in writing in a caregiver agreement, a written agreement to be paid for care, they're locked in. They are committed, and that's what you are also ultimately need. You need committed team members to provide care. So there's this formalization of the care team by putting it in writing. That's a huge benefit, in my opinion. But there's also something to be said for family harmony. So I can't tell you how many times I've encountered families where maybe the local son or daughter is carrying most of the weight here with providing dementia care. They're putting in all the time, all the energy. They're giving up the sleep. They're giving up the time with their family and friends. But 2 or 3 states away, there are siblings. And the siblings offer really nothing but criticism of how things are going at home with mom or dad with dementia. And to give them the most benefit of the doubt, those out-of-state siblings may just not be aware. They might not have a clue how much time you, the local caregiver, the local family member, are putting into caregiving. They might just have no idea what you are experiencing on a day-to-day basis. In the worst case scenario, the out-of-state family member starts making accusations. Why is all this money going from mom to you? They might think you've manipulated mom. I've heard all these stories. You don't want to be the recipient of accusations. You don't want to be the subject of suspicion. You want to simply be recognized and compensated for all the hard work you're doing. Well, once everything you're doing is in writing, and it's in writing ahead of time before you've even done the tasks, and then the tasks are recorded as you do them, it's transparency. You can show the out-of-state family member, here's a record, full disclosure, everything I've been doing, and then they get a real sense of everything you've been doing, and it might go a long way to helping them understand how much you're doing, giving you positive reinforcement for all that you are doing for the loved one. It will clear up, I hope, a lot of the potential resentments. They may even feel guilty that they're not doing half of as much as you are doing, or even close to half of what you are doing. But you still want to communicate with those folks. Once you put everything in writing, the payment arrangement, you're still going to use that as a foundation and then have a conversation with them before the agreement is signed. As the money starts changing hands, you want to have a disciplined, regular conversation showing them, show your work, be fully disclosing everything that you're doing and the money changing hands for the work that you're doing. But again, back to the technical legal side of things, when it comes to facility-based care especially, Medicaid pays an awful lot of money for long-term care. It might pay for care in the home, professional care. It might pay for assisted living, especially memory care. It almost always pays for nursing home care, the highest level of care. But the Medicaid rules are tough. So here's another aspect of Medicaid where a written caregiver agreement can really help. Have you ever heard of the 5-year look back? That's a tricky Medicaid rule. What that means is to get eligible for Medicaid to pay thousands of dollars every single month for your loved one's care, they're going to look at bank statements. They're going to look at investment account statements. They're going to look at all kinds of financial records and tax records for 5 years. It will be a very large stack of paper. And Medicaid is looking for at least one thing. They want to know in the last 5 years, was mom or dad just giving money to the kids or the grandkids only to turn to the government and say, I'm broke, pay for my care? They frown on that, so they build in this 5-year period in every state except California, where the rules are always a little different. Every other state, if you've given away money in the 5 years before you apply for Medicaid, they impose a penalty period. And how long that period is will depend on how much gifting has happened in the previous 5 years, but they're going to penalize gifting by saying, you pay out of pocket for your care, come back to us when your penalty period is over, then Medicaid will kick in. Well, you want to have a record that mom or dad with dementia is paying for something of value. They're not giving money away. They're paying for something which the law definitely allows them to do. They can't just give away the money, but they can pay for things that they need. So this written caregiver agreement is rock solid proof of what they agreed to pay for, what was done, and the money changed hands, and you can show this was not a gift. This should not be penalized with a gifting penalty. Medicaid should kick in right away. So again, when you write all of this down, when you have everything in writing, it is a dream scenario for an elder law attorney to get Medicaid paying for long-term care when that becomes appropriate, because there's no gifting problem. And so the written agreement goes a long way to some future need for Medicaid to pay for facility-based care, especially. It may even preserve the entire value of mom or dad's house. What do I mean there? Have you ever heard somebody say, if I go to a nursing home, they're going to take my house? Well, it's not the nursing home taking the house. It's when mom or dad dies, now the house is in their estate. Well, that's where Medicaid gets paid back for all that care they were paying for. So they go to the estate and say, what do you have that we can force the sale of and then get paid back all that money for the cost of care? So if they pay for $300,000 worth of care for mom or dad and they see a house, they want the house to be sold and all the money goes to the government to pay back for the care. Well, some of you, I realize not all of you, but some of you might be caring for a parent with dementia and you're actually living in the house. You're living at mom or dad's house. And in fact, you gave up your own place to live. Well, there's an important exception to Medicaid coming after the house when mom or dad dies to get paid back for all the care. And that exception is called the child caregiver exception. So if you can prove you were living with mom and or dad, you were providing care that in fact kept mom or dad out of a nursing home and off of Medicaid longer than they otherwise would have stayed out of the nursing home, then the government recognizes your sacrifice and says, you know what? We're not coming after the value of the house. You keep the house. So how do you prove that? Well, a written caregiver agreement goes a long way to showing that you were living there. If in fact that's your circumstances, this is a great way to take that exception and keep the entire value of the house in the family. So what should the caregiver agreement say to get all of these benefits? First of all, it's a forward-looking document. So you can't with a Medicaid application for the first time try to say, well, all that money that you see in these financial records going from mom's account to me, that was payment for services. They're not going to take your word for it. You have to have this in writing and then do the caregiving and have the money change hands to be able to prove that this was not a gift, this was payment for services. So it has to be a forward-looking document. You have the agreement, it lists what's going to be done, you do the things, the money changes hands from the day of the agreement going forward. And then it's really good proof that it was not gifting. So what should the agreement say? It should set forth all of the tasks that you do for mom or dad with dementia. So if you are if you're doing transportation, if you're taking mom or dad to doctor appointments, if you're taking them out to grab a cup of coffee, to see some of their old friends, first of all, you should be doing that. That's that kind of sensory stimulation from interacting with the world, that kind of obviously getting to medical appointments and other necessities, just having social interaction. Our brains need that like our bellies need food. So I hope you're doing those things rather than leaving mom or dad isolated in the home. But of course, in doing that, you're putting mileage on your car. You're incurring the cost of gasoline. So the agreement should probably say something like the mileage will be reimbursed at the IRS prevailing rate. So if that's 67 cents a mile, great. That we can back that up at any given time. We can Google what the IRS rate is at any given time, but you put it in there. I'm going to do transportation and then obviously you're going to keep track going on. And I'll talk about that in a moment. What else do you do? Are you mowing the lawn? Okay, put lawn care down in the agreement as a task that you will complete. Are you cleaning the house? Are you maintaining medications for mom or dad with dementia? Go through your day mentally, all the things you do, and don't overlook something like companionship. Sometimes you just sit and be in the present with your person with dementia. That's where they live. They live in the present. Be there with them. That's valuable to them to be there and maintain their positive mood and look out for any physical needs. Your companionship is of extremely high value. Put that in there. So you're going to put everything that if you go through your day with your loved one with dementia, put that in the agreement. These are things that I will be doing, or some other family member or friend will be doing. Put it in there. The next thing you want to figure out is how much payment will happen for each of those tasks. And it has to be a market rate. What do I mean by that? That means you can't say, I'm going to mow the lawn, and every time I do that, I'm going to be paid $5,000. Medicaid would definitely see that as excessive. Medicaid would see that as gifting and penalize it accordingly. It has to be what would you pay a professional in the community to do the same task. So you can look up what the lawn care company would charge in your community for companionship, medication management. What would a home care agency charge in your community? Because what you're trying to do is really what the home care agencies do when you hire them. They have a plan of care. There's no doubt about what needs they have assessed, what they're going to do to serve those needs, and then they keep meticulous track of what has been going on in any given day, and then there's no doubt about what they're being paid for. You want to approach the same kind of result. You want it to be very clear, what am I doing? What will I be paid for each of these things? And obviously the market rate for cutting the grass and for cleaning the house, these might be a little different. And there are ways you can search labor statistics for various communities and various services and come up with a fair rate. Just keep in mind when you look at the lawn care company or the home care agency, what you pay them for a service is not entirely what's going to the guy cutting the grass or the caregiver coming to the house, because some of what you're paying the company is overhead to keep the company going. They need to keep their lights on and pay all their bills. So the caregiver or the guy cutting the grass are getting paid something less than the total amount. You need to pay yourself what the actual service provider is being paid. So if you're paying $30 an hour for a home care company, I'm willing to bet probably closer to $15 or maybe $16 an hour is actually going to the caregiver. That's what you pay yourself for an hour of companionship and meal prep and medication management and all of that. So this is, again, where elder law attorneys can ask a lot of good questions and search out market rates and make sure it's all in there. But once you have the tasks, you have what the payment will be for each of the tasks. Here is an incredibly important part of putting everything in writing. You need to keep a log. You need to record everything as it happens. Because put yourself in the shoes of Medicaid looking at transfers of money out of a bank account to you, and they're saying it's gifting. No, you want to be able to say this is a task in the agreement, then this is the record of the tasks being performed. So when you see a transfer of money, I can tell you exactly when I did it. So keep your mileage and then pay yourself the IRS prevailing rate for that mileage. Keep your time. I spent time sitting with mom, showing her an old photo album, having coffee. Write that down. How much time did you spend? Trips to doctor's appointments, everything. Just write it all down as you do it. You may have heard a recent episode of the show where I was speaking to Nancy Myers, who came up with a software solution called AdvoCord. And I don't have any interest in AdvoCord. I don't have no financial interest or any other interest. I just think it's a great idea. And AdvoCord works for all kinds of scenarios like guardianship and using a power of attorney. And in here with the caregiver agreement, it's perfect because you can keep receipts. If you're going to reimburse yourself, how are you going to prove to Medicaid later or to your jealous or resentful family members later that this was not just money coming to you, it was reimbursement for something you already paid for? You take a picture of the receipt and you load it up into your AdvoCord account very easily into the right folder for receipts. You can put the actual caregiver agreement into the legal documents folder in AdvoCord. So I'm not saying you have to use AdvoCord, but it's perfect for this because you can do it all from your phone and everything is kept in a very organized way rather than a big box of assorted paper that you might have keeping track of everything. But whether you do it with pen and paper and a box of paper or whether you do it with AdvoCord, just write it down because proving you did the tasks when you did them, and there you need to do that if money is going to change hands. And finally, you might be thinking, well, who's signing this agreement? Because if it's an agreement, that means there's two parties to the agreement, at least, and this is a legal document. What if mom or dad with dementia can no longer sign an agreement? Well, that might be true. So who knows? Maybe they can. And we elder law attorneys have guidance from our state courts on the ethics of what do you have to show as far as cognitive capacity to sign a legal document. And we would be asking certain questions. But who's going to dispute that this was valid among family members? You might talk to people and say, does everybody agree mom's still pretty much at a place where on the right day, at the right time of day, if she's having a good day, she understands. She's forgetful. She's having trouble coming up with language. Words escape her. But if we explain this, she'll understand what we're talking about. If everybody agrees upon that, you might be okay to have mom sign the agreement. And then if you're the one who's you or and anybody else who's going to be paid also signs the agreement, you might be good to go. But even later on, where mom definitely does not have the capacity to sign a legal document, are you the power of attorney? Or is somebody else holding a power of attorney? Because with a halfway decent power of attorney, clearly that person can act as mom to sign a legal agreement. That's one of the more important reasons to have a power of attorney. And then your next question is, well, it's me. I have the power of attorney, and you're telling me I should sign an agreement where I pay myself? Isn't there a conflict of interest? Well, if it was a really well-written power of attorney, this exact situation was anticipated, and the power of attorney will say, yes, you may pay yourself. Elder law attorneys think about these things well in advance. That's how we're drafting the estate planning documents in the first place. So the answer to your question is going to be in the power of attorney. Does it allow you to sign on behalf of mom? I certainly hope so. And then does it allow you to enter into an agreement where you are getting paid for something of value? I hope so. I hope it was drafted that way. You never know. If mom went to the local attorney who practices real estate and criminal defense and personal injury, I have my doubts that the power of attorney will really be set up for this exact scenario. But that's just something to consider, that mom can sign it, or if mom is no longer able, whoever has the power of attorney can sign it. And then it's just a question of, did mom waive any sort of conflicts of interest? So I've covered the benefits of getting paid as a family caregiver, even just a psychological benefit of your value being acknowledged. I've talked about why you really want it to be in writing if there's going to be a payment arrangement. And then I've talked about what goes into that written caregiver agreement. I hope this has been helpful. You can do this. You can do dementia caregiving. And if you need help, contact me at info@keystoneelderlaw.com. I lead 8-week courses on dementia care skills, and I'd be happy to work with you. Coming soon, an online guidance, an online course that will take you at a self-guided way through the legal, the financial, and the care skills. But until that time, and even beyond that time, happy to work with you. Happy caregiving. Hang in there. You can do this.